The North Carolina appellate court left an injured plaintiff in the cold. In Crews versus W.A. Brown & Son. 13-year-old Vickie Crews was working at Calvary Baptist Church one evening in 1985. Crews was a volunteer and a church member. Crews entered the church's walk-in freezer to grab some ice for her drink. At the time, Crews was wearing shorts, a t-shirt, and no shoes. The freezer door shut and locked behind Crews. While the freezer door was equipped with a door latch assembly that should have permitted it to be opened from the inside, the assembly failed. Crews was trapped in the freezer for over an hour and suffered severe frostbite to her feet, legs, and buttocks. Ultimately, Crews lost 9 toes to the frostbite. The church had purchased the freezer from Foodcraft less than a year earlier. Foodcraft didn't manufacture the freezers it sold. Rather, Foodcraft contracted with W.A. Brown & Son to purchase the necessary parts to assemble the freezer on site at the church. After assembling the freezer at the church, Foodcraft employees tested the door and made sure it could be opened from the inside. At that time, the latch assembly worked. When she was trapped inside the freezer, Crews saw frost on the inside of the release button. Frost accumulating in the release mechanism was likely the reason Crews couldn't open the door from the inside. The frost likely resulted from improper installation of the seal separating the plastic cover of the latch assembly from the metal freezer door. Crews sued Brown, Foodcraft, and the church in North Carolina State Court. Crews alleged that Foodcraft was negligent in assembling, installing, and inspecting the freezer. Crews also argued that Foodcraft had breached express and implied warranties of merchantability and fitness for a particular purpose. Brown, Foodcraft, and the church moved for summary judgment. The trial court denied Brown's and the church's motions, but granted Foodcraft's. Crews, Brown, and the church appealed. The North Carolina Court of Appeals dismissed Brown's and the church's appeals. Left was Crews's appeal of the trial court's grant of Foodcraft's motion for summary judgment.